I'm Sandy Weinberg. I'm with the Zuckerman Spaeder law firm from the United States. I've actually practiced in Tampa. And we're going to do something that we haven't done in the 8 years. We're going to do one on sentencing. Occasionally our clients get sentenced. So it turns out that they get sentenced a lot more in the United States than they do other places, I think. So we're going to, a little different panel than I normally have where I try to get everybody talking. We're going to have some presentations and then everybody will talk for a while. We're going to have panelists from the UK, from Germany, from Italy, and Spain. And I'm from the United States, so I'll serve as the person that supposedly knows something about the federal sentencing guidelines in the United States. It turns out that the sentencing schemes in the EU are vastly different from one another. So if you have a cross-border case, it really makes a big difference where you end up, and all of them are remarkably different than the United States. As y'all probably know, and you'll find out more today, the penalties in the United States in white-collar cases far exceed anything in any countries here in Europe. But we're going to discuss a little bit corporate and individual sentencing, the role of plea bargaining, and really you'll see the vast differences amongst the countries, so that if you are able to pick the venue where your client gets sentenced, it really does make a big difference and stay out of the United States. We have some terrific panelists today. At the far end there is Julian Roberts, who is one of the leading experts actually in the world on sentencing guidelines. He's one of the authors of the England and Wales sentencing guidelines. So if you're in Scotland or Northern Ireland, you don't have sentencing guidelines. But in England and Wales, you do have sentencing guidelines. He's served on the various commissions in the UK and in Canada with regard to sentencing guidelines. He's a professor of criminology at Worcester College in Oxford and remains actively involved in the guidelines. Dr. Ulrich Leimenstoll, right here to my right, is a partner at the Gercke Wollschläger law firm in Cologne, Germany. I'm very involved with one of his partners in the VW case. He's a criminal defense lawyer. Their firm is one of the leading boutique criminal defense firms in Germany. He focuses on business, physicians, and medicine, and his firm has been involved literally in all the big white-collar cases in Germany, and there have been a number in the last few years, including the diesel emission scandal. Francesca Pedrazzi, third here on my right, is from Italy. She's 30-year practitioner, exclusively defending Italian and international clients in white-collar and international crimes. Most of her career, she was at a big firm, but in the last few years, she has her own boutique firm in Milan, Italy. And then last but not least, Adriana de Buerba, who is from Spain. Which city?
Madrid.
Madrid. She's a white-collar specialist. She's the chair of one of the large Spanish firms, Pérez-Llorca. And she's chair of the white-collar department. She's been there since 2008. And for a decade before that, she was a prosecutor, a public prosecutor in Spain, and did white-collar cases. And she's been involved in a number of corporate compliance matters in the field of anti-corruption and money laundering, and about half her work is with international issues. So she does a lot of cross-border stuff. I've practiced for the last 44 years in the United States, mainly concentrating on white-collar stuff. When I was a baby lawyer, I was a prosecutor in the Southern District of New York, and it was so long ago that it was before the federal sentencing guidelines. So all of the big white-collar cases, and that's what I did in the Southern District prior to, I was there from 79 to 85. We didn't have federal sentencing guidelines. Virtually everybody that we prosecuted, they didn't go to jail. Or if they went to jail, they went to jail for a short period of time. Our world changed in 1987 in the United States. We had the first federal sentencing guidelines, and what they did was they ensured that people that were prosecuted in the federal system went to jail, and in particular, white-collar defendants. Our guidelines, unfortunately, from 1987 to 2005 were mandatory, and it was awful. Judges didn't have, and they really didn't have discretion. You know, you were like a mathematician, and you calculated the guidelines, and it said jail, and in white-collar cases, it said a lot of jail. And in 2005, you know, a miracle happened, and the Supreme Court, in a case called Booker, made those guidelines advisory, and they weren't mandatory anymore, except for the fact that most judges at that point still considered the guidelines as the Bible, and they imposed them. But now, as time has gone on, since 2005, more and more judges have exercised, finally, some discretion. Still, the guidelines really sort of set the base, and those guidelines are very strict, and it literally means jail for your white-collar defendants. So, as you'll see today, where you are prosecuted does make a difference at the end of the day, and it's a good thing to know something about, you know, what you're looking at. So I thought we would start with some PowerPoint presentations. Hopefully we have the bugs worked out so that they'll work. And well, why don't we start with Julian Roberts, and he's a professor, so he's standing up, and he's and he's going to lead us through the England and Wales. I said UK when I first did this, and he corrected me. It's England and Wales sentencing guidelines, right?
That's correct.
Okay.
Thank you very much, Sandy. It's a great opportunity to be here with this distinguished panel of practitioners, and great to see our friends from America here at what is a very critical time in European history. We're all very worried in the United Kingdom about Brexit, as I'm sure you've been reading. We're very concerned about what will happen to Europe without us. You know, how will the Europeans manage without our leading parliamentary system? Will Europeans be denied access to British culture, cuisine, our beautiful beaches, sunny weather? So we're worried. And on a political level, I mean, without the United Kingdom, some nation may take over in Europe. Imagine Europe run by the French. Mon Dieu. Poke at the French. There are no French panelists. So we wouldn't want that. Anyway, let's not be pessimistic. I'd like to talk about sentencing white-collar crime in England and Wales today. And I want to do the following three things. Talk about the English guidelines, which are quite distinct from the American counterparts, and the council which devised and currently issues those guidelines. I'll give an example of the offence-specific guidelines, the one for fraud, bribery, and money laundering, which I have a copy of which here. We have offence-specific guidelines in England and Wales. They all come in a nice, different, beautiful colour. This is purple for fraud, etc. Assault, I think, is red. Environmental offences guideline is, you guessed it, green. So they're certainly very pretty guidelines, and we'll see what you think about their contents. I'd also like to talk a little bit about sentence discounts for plea-based sentence discounts, which are a lot more modest in England and Wales than the US, Canada, and Australia probably as well, but also more predictable and transparent. And I think that's sort of an interesting issue. And if I have a moment at the end, I might try and sneak in a few words about deferred prosecution agreements. But a word about the Sentencing Council of England and Wales. So this has been running since 2010. We issued our first guideline in 2011. And there are big differences between the English Council and the Minnesota Sentencing Guidelines Commission or the US Sentencing Commission. And I think I won't go into all those, but the primary distinction, I think, is the membership of the English Council is primarily judicial. It's headed by the Lord Chief Justice, and the members include representatives of all levels of the judiciary in England and Wales, whereas, for example, in Minnesota, there are only 3 judges on the Minnesota Commission, the same number of places as is reserved for members of the public, which I find odd. So we're a primarily judicial body, or the council is primarily a judicial body. I'm no longer on it, left last year. And its primary duties are, of course, to issue guidelines, obviously, to monitor the effect of those guidelines. And periodically, if the government comes up with some bright idea in the direction of sentencing, as they are, in fact, announcing today in the Queen's speech, the council has a statutory duty to assess the implications in terms of prison places and so on. So you'll be familiar with the US-style grids, Minnesota, 2 dimensions. Note the dimensions, severity and criminal history. Now, this was a big departure for us in England and Wales. We came to the conclusion that the primary dimensions should not be offence seriousness and prior convictions, but they should reflect the twin components of a proportionate sanction, and that would be harm and culpability. Now, possibly criminal history serves as some kind of a proxy for culpability, but it's obviously much broader than that. So when you see the English guidelines, you'll see that we have a grid of a form, but the dimensions are harm and culpability. And we have a methodology. Rather than presenting a grid and you enter the grid at a particular point and find the matrix that's appropriate, we have a methodology. Courts sentencing an offender or a corporation in England and Wales have to follow the steps. And there are between 7 and 10 steps. The guideline structure varies from offence to offence. But essentially, there's a common methodology, which is to match the case at bar to the grid definition of levels of seriousness and culpability. You're then given a starting point sentence and a sentence range to work within, and you follow the various steps. There are, as I say, a different number of steps in the various guidelines. And the one I'm talking about today, fraud, bribery, and money laundering, I'll talk about sentencing individual offenders, but at the back, I didn't put it on the overhead. In the back, you'll find the corporate sentencing methodology, which has a couple more steps for reasons which we might discuss later. So these are statutorily binding guidelines. There is a duty on any court sentencing an offender to follow the guidelines relevant to the particular case. And of course, this means all courts. This includes the Court of Appeal Criminal Division. Key differences between the English guidelines and the US, ours are offence specific. I've mentioned that. We also have generic guidelines. They apply across cases. So we issue guidance as to totality, sentencing offenders convicted of multiple crimes, plea-based discounts. I'll talk about that. There's more discretion in the English guidelines than in the Minnesota grid or Pennsylvania and so forth. And we have this separate guideline, which I'll talk about. I'll come back to this if I have a chance. I would like to get into giving you an example of an offence-specific guideline. And here is the fraud, bribery, and money laundering offences. So we begin, well, here's the overview. You determine culpability and harm using guideline factors. The guideline gives you factors. Then you consider additional mitigating and aggravating factors to shape and hone the provisional sentence before proceeding through the remaining steps. Probably can't read this, don't really have to. This is step 1, and you can see there 3 levels of culpability, high, medium, and lesser. So that's the first step. Determine whether this case is high, medium, or lower culpability, this offender, using these factors. And You also have to determine harm. So we start with culpability, we move to harm, and we've got harm A and harm B, depending upon the different particular offenses. So we might imagine, let's go back to this one, we've got a high culpability offender, and let's imagine that harm is also high, category 1. So those two combined will trigger this grid-based format. And you can see here, category 1, culpability A, starting point 5 years of 6 months to 6 months, 5 years, 6 months custody, and a category range 4 to 6.5 years, maximum penalty being 7 years. And so a court will use the starting point sentence, go to the next step of the guidelines where additional mitigating and aggravating factors are displayed, and move that starting point up and down to reflect the degree to which these factors are relevant. And then you'll come up with a provisional sentence, let's imagine 48 months in prison, and then you proceed through the remaining steps of the guideline, which I won't trot you through here. I will just bring your attention to step 4, which is the guilty plea reduction, and I'll come back to that. So you follow the methodology, and the last step, or last of the 7 steps for this particular offense, is to give reasons for the sentence. I seem to have chopped off the guideline there, but you can. So let me talk a little bit about the generic guideline sentence reductions for a guilty plea. And this is part of, I think, a movement towards greater transparency and predictability in English sentencing law. And it's probably true for the other common law jurisdictions, that they don't quite have the degree of transparency or predictability. If you're charged with a serious income tax evasion offense in Canada, let's say, another jurisdiction I know quite well, you ask your solicitor, well, I'm thinking of entering a plea. What's the reduction likely to be? What's in it for me? And the solicitor will have to say something like, well, it depends. I've got to talk to the Crown. Depends which judge we get it before. Depends if how much information you will be able to share. If there are other possible defendants and blah, blah, blah. You'll be better off. We can't really say anything more than that. And the council, we thought, and before us, we thought that solicitors should be better prepared to advise their clients as to the benefits or costs of pleading guilty. And so we have a guideline which does this. Here's the statutory foundation for it, which is very general. So it just identifies the stage in the proceeding as the driving factor. That's not hugely helpful. So we have a guideline which represented here, and we've just recently, it's just been tightened. This is last year's guideline, and now if you enter your plea at first reasonable opportunity, you are entitled to a maximum of 1/3 reduction. And that's a pretty robust presumptive reduction. Occasionally courts will go above, and occasionally they'll go underneath for various reasons, late disclosure and so on. But if you enter your plea at first reasonable opportunity, that's the first appearance in the magistrate's court, you will get 1/3. If you wait a while, it'll decline, the reduction will decline to 1/4. And if you change your plea or enter a guilty plea on the day of trial, you're entitled to a 10% reduction and no more than that. And we think this is useful because it gives clarity to the plea-based reductions and enables litigants and their lawyers to understand exactly what's on the table. Differences in discounts between England and the US. Well, the 1/3 maximum, I think, is more modest. There's far less negotiation between the parties here than in the US, Canada, Australia. Joint submissions rare, and so on. So that's all I want to say about it, but I just make one last quick comment about DPAs. The corporate guideline at the end of this guideline lays out detailed guidance on what is likely to happen if somebody's convicted of the offense, if a corporation is convicted of the offense. And this is supposed to be a guideline which will facilitate interactions between the parties, facilitate a deferred prosecution agreement. So it serves as sort of a dual function. DPAs are obviously a bigger topic than we have much time for today, but I just wanted to flag that for your attention.
So before you sit down,
yeah.
Have the guidelines led to more, less jail time for white-collar offenders?
Yeah, so it's an interesting question. There hasn't been a great deal of evaluation research on the English guidelines, unlike the US Sentencing Commission, which has spawned a huge amount of research. The English guidelines appear to, in terms of corporate sentencing has become tougher as a result of the recent guideline. So, for example, for a corporate manslaughter conviction, the record fine was £700,000 until recently, and the most recent prosecution resulted in a fine of $2.4 million. With respect to white-collar individual offenders, we don't have robust data. The best evidence we have is that sentencing has become a bit more predictable and consistent and hopefully more proportionate, but it hasn't affected the overall, at least we've got no evidence that it's affected the overall severity of punishment of white-collar offenders.
And one last thing, just quickly, are they mandatory? Do the judges have to use the guidelines?
Yeah, the statutory compliance requirement is that courts must follow any relevant guideline, but there is the additional wording of unless it would be contrary to the interests of justice to do so. About 95% of sentences imposed fall within the guideline, any guideline in England and Wales, and you may think, well, that's massive compliance, and that's much higher than Minnesota or Pennsylvania and so on, but there's a lot more room in our guidelines, so the compliance statistic is a little misleading. But yes, courts are required to follow, and that's a statutory requirement.
So why don't we hear from Germany, Uli, and while you're getting up there, Julian talks about Minnesota and Pennsylvania. So in the United States, we have federal guidelines that are for all the federal cases, all the DOJ or U.S. attorney cases. Those are the ones I'm most familiar with. But I forget how many, 18 states, I think, in the United States have their own guidelines, Minnesota, Pennsylvania, Florida. And so, you know, we're, as criminal defense lawyers, we're dealing with guidelines. The other thing I can say is that in the United States, about 50% of the sentences are actually below the sentencing guidelines. Half of those are driven by recommendations from prosecutors, which is something we can talk about later, which, you know, really was a problem with the mandatory guidelines, I think. And the other half, though, are through judges deciding on their own, because now after this 2005 decision that made the guidelines advisory, judges do have more discretion now. And about half of that, or about 25% of the sentences are below the guidelines on decisions made by judges to vary from the guidelines based on other factors. So, Uli, tell us about Germany.
Well, thank you. I stand, although I'm not a professor. Well, I thank you for the kind introduction, Sandy, and for inviting me. I'm honored to be a participant of this panel today. In the next minutes, I'll try to give you a rough idea of the German sentencing regime and its characteristics. As Sandy told me that he'd be interested in how the so-called diesel scandal is handled in Germany, I refer to the current VW case from time to time to explain that in my illustrations. So how do we deal with white-collar crime? Just a few exposed and particular examples to get started. Klaus Zumwinkel, the former CEO of the German Post, was sentenced to 2 years of imprisonment for tax fraud with a fiscal damage of nearly 1 million euros. The sentence was suspended. Uli Hoeneß, the president of the Bayern Munich football club, got sentenced to 3.5 years for tax fraud with a fiscal damage of around 27 million euros. No probation. Jürgen Schneider, the construction tycoon, was accused of credit fraud, forgery, and bankruptcy with a damage of about 300 million euros. And he was sentenced to 6 years and 9 months of imprisonment. Bernie Ecclestone, the former chief executive of the Formula One, was indicted for bribery amounting to 44 million euros. The trial was terminated without conviction in exchange for a payment of 100 million US dollars as monetary condition in favor of the Bavarian state treasury. I don't want to withhold the postcard he sent to a German news magazine afterwards.
What's it say?
This is not a robbery, I'm collecting for the Bavarian state.
It pays to be rich, I guess.
Back to the basics of sentencing. The applicable range of sentences is determined according to the offenses committed. The German Criminal Code defines a penalty range for each criminal offense. For some, there are codified adjustments for less severe or particularly serious cases. If the same act violates more than one law or the same law more than once, only one sentence shall be imposed. And if a person has committed more than one criminal act, all of which are be adjudicated at the same time, an aggregate sentence is imposed. The maximum of fixed term imprisonment is 15 years, and a suspension is not possible if the sentence exceeds a term of more than 2 years. So the former CEO of VW, Mr. Winterkorn, was recently indicted for fraud and infringement of the law against unfair competition and embezzlement. And he's accused of having dedicated just one act. Therefore, according to the principles of the German Criminal Code, the possible range of sentences is imprisonment from 6 months to 10 years, as the most severe approach is fraud in a particularly serious case. Just another VW example to illustrate the implication of the aggregate sentence. Oliver Schmidt, a former VW manager at a lower level, got 5 years for fraud and 2 years for a false statement under the Clean Air Act in the United States. So he ended up with a prison sentence of 7 years. An aggregate sentence in Germany would most likely be something from 5.5 to 6 years, but not 7.
And that's a reason not to visit Florida when there's an investigation going on, because Oliver Schmidt, who was a really fairly low-level guy, took his family on a vacation to Florida. And unfortunately, there was a sealed indictment, and he got arrested at the airport, pled guilty, and it ended up with 7 years, which is just unbelievable because of our guidelines. And, you know, the CEO of Volkswagen and this multi-billion-dollar fraud, I guess maximum is looking at, what, 10 years?
10 years. Well, there's a new indictment for the manipulation of markets, so we'll see. But, however,
well, that's unless he somehow decides to go to Florida. You cannot get extradited. Germany will not extradite a citizen?
No, they would not.
Okay.
Well, he gets what he deserves in Germany. That's what the Germans think. All right. Section 46 of the German Criminal Code lays down the principles of sentencing. The guilt of the offender is a decisive basis for sentencing, but the court also has to take into account the effect on the offender's future life as well as the circumstances in favor of and against him, like its motives, the consequences caused by the offense, his prior history, and so on. But how are these principles filled with life? We do not have sentencing guidelines in Germany. Therefore, there's a wide margin of discretion within the prescribed penalty range. The German Federal Court has coined the term room for maneuver. It says, it's not possible to determine exactly which punishment is appropriate. There's room for maneuver here, which is limited at the bottom by the penalty already appropriate and at the top by the penalty still appropriate to the crime. The judge may therefore not impose a penalty that is so severe in amount or type that he himself no longer considered it to be appropriate. But he may, however, at his discretion, decide how high he is to reach within this margin. So the court's able to exceed the term recommended by the public prosecutor, which does not happen very often, and it's even not bound by the indictment, so it may change the accusation after an indicative court order, as long as it relates to the same criminal act. The court has to establish and elaborate all the circumstances which are relevant for the sentence and it has to provide a comprehensive written body of arguments explaining the reasons for the judgment. When it fails to do so, or the grounds seem to be unreasonable or too lenient, this may give rise to an appeal. Well, a recent study shows that in general, courts in the south of Germany tend to be harsher than the ones in the north. So statistically, it's good for Mr. Winterkorn to be charged in Braunschweig than, for example, in Munich, which is the court responsible for the Audi case. But at this point, I think a serious and well-founded estimation of the likely outcome is just not possible, even if we assume that Mr. Winterkorn is found guilty, as I don't know how he will position himself in the trial. But from my perspective, it's hard to imagine that he could get more than the 7 years that Oliver Schmidt got in the United States if he tendered a confession. But we'll maybe come back to this point later. There's two more aspects I'd like to touch. In Germany, we don't have a plea bargaining like in the Anglo-American system. A professor from Dallas has summarized the differences as follows. In describing the German practice of exchanging an admission of guilt for a reduced sentence, the term negotiated judgment is technically more accurate than the term plea bargaining. German defendants do not merely enter a guilty plea, but rather tender a confession which does not obviate the subsequent trial.
Well, let me interrupt for a second. So in fact, even if you're indicted, you still have to stand trial, right? In Germany, there has to be a trial. You can't just end it with a plea.
There's some possibilities to avoid a trial in minor cases, but if we're talking about a serious fraud case like this, you have to go to trial.
But if you do you get some break if you go to trial, but you're not really being aggressive as far as defending yourself? Do you get a break for that as far as the sentence is concerned? I mean, there are people that are on trial that would like to plead guilty, right?
Yes.
And so how do you articulate that?
So you start with your confession, and then afterwards the court has to take evidence to check whether you told them the truth or not. So, and if
I didn't tell them the truth, then what happens?
Well, then you won't get any reduction, but maybe something on top. They will never tell you, but it's like, okay, 6 months more, all right, and 1 year more. But
all right.
Well,
it's very different than it is in a lot of other countries.
Yes, but back to the German deal. For a long time, the established practice of agreements in criminal proceedings was only characterized by the jurisprudence of the German Federal Court. The so-called deal was not legally codified before 2009. And still after the codification, critics bemoan that the inquisitorial character of the German criminal procedure is displaced to an unacceptable extent by the adversarial Anglo-American system of bargaining. Although a deal may not include an agreement on the conviction, and the court has to verify the credibility of the confession, which means that there has to be taken of evidence. The court can consent an upper limit, and this was new in 2009, a lower bound regarding the sentence. But in any case, the sentence has to be appropriate to the crime. So the gap between an agreed frame of possible sentences in case of a confession and the threatened penalty in case of a controversial trial may not exceed a justifiable extent, as the defendant may not be subjected to unacceptable pressure. The German Federal Court has, for example, annulled a decision where the defendant was sentenced to 3.5 years after a confession, but the court had threatened to condemn him to 7 or 8 years in case of a disputed trial. So therefore, Mr. Winterkorn will most likely not get an offer like it's 4 years or 9 years, up to you. There's always the opportunity to appeal, as a waiver is excluded if a negotiated agreement has preceded the judgment. And my last point. To this date, we do not have a criminal law for corporations and enterprises. But there's an ongoing debate, and the so-called diesel scandal is always mentioned as an example illustrating the alleged necessity of harsher legal regulations. The present German government has anchored the intent to introduce such a law in the coalition agreement, and our Ministry of Justice has just presented a draft legislation of a law to combat corporate criminality. proposing inter alia financial fines up to an amount of 10% of the worldwide turnover of the respective enterprise. Is this necessary? On the basis of the current act of regulatory offenses, VW paid a financial fine of 5 million euros for having violated the duties of supervision, the maximum amount in case of mere negligence. But they paid another 995 million euros as part of asset forfeiture measures. Well, that's a better price than they had to pay in the US, but still a severe sanction in my eyes. The whole VW group paid about 2.5 billion euros. This includes Audi and Porsche, and this does not include any civil resolutions. So against this background, I doubt if Germany really needs new draconian sentences to fight corporate crime. But what do you think? Thank you very much.
So before you sit down, in the United States, VW paid, what, 10 or 11 billion, something like that? So things are really vastly different in the United States than Germany. Francesca,
Yes.
tell us about Italy.
Okay, can I have the
clicker. Yes.
Thank you, Sandy, and it's a pleasure and an honor to be here in this, before this audience.
And can everybody hear?
Sorry.
Get the microphone a little closer to you.
Okay, thank you. It's a pleasure and a great honor to be here before this very distinguished audience. I'll try to give you a very short presentation of of how sentencing works in Italy.
The other way around.
This one. Okay. And as a starting point, of course, who can be sentenced? Until 2001, we only had individual liability in Italy. Now, since 2001, we also have corporate liability. The law defines it as administrative liability, but in fact, it's a quasi, or according to some people, it's a completely criminal liability. It arises out of criminal offenses committed by company representatives in the interest or to the advantage of the legal entity. It gets established in criminal proceedings by the criminal court. It depends on the presence of an organizational fault, and so it follows the rules of criminal procedure. However, as we will see, there are important differences in the way it is perceived and prosecuted. And this has an impact on the possibility, for instance, to find alternative mechanisms for the resolution of criminal proceedings. Sentencing must conform to constitutional principles, and I will just go to constitutional principles that have an important impact. Penalties, according to the Italian constitution, must tend to the rehabilitation of the offender, so no death penalty would be possible in Italy. We have life imprisonment as the maximum penalty. Another principle which is very relevant for sentencing is the principle of mandatory prosecution. The prosecutor in Italy has the obligation to prosecute all criminal offenses, and he has no discretion to dismiss cases if he finds that the evidence is not sufficient to support a case. He has to apply to the judge, and it is the judge who has to decide on the case dismissal. So the prosecutor cannot do it by himself. But it's different in the area of corporate liability, because in respect of corporate proceedings against corporations, the prosecutor has the right, the possibility to dismiss a case. However, we have a very high degree of ineffectiveness of corporate liability. And in fact, in 85–90% of cases, criminal proceedings are brought only against individuals. This depends on a series of reasons: lack of resources, lack of practice with this kind of statutory instruments by some prosecutors. There are big differences over the country. For instance, in Milan, the rate of prosecutions against companies is much higher than in the south of Italy. But this means that despite the principle of mandatory prosecution, there is a de facto discretion in filing cases against companies. And as I said, there is no judicial supervision over dismissal of cases. Coming to the structure of sentencing, sentencing authority belongs to the trial court or the single judge, depending on the cases. At the end of trial, the court comes out with a unitary decision which defines all the issues, the issue of guilt or innocence, the legal qualification, and the determination of the sentence. We have no sentencing guidelines and wide judicial discretion, which is, however, subject to statutory limitations that define the types of sanctions, both in general terms and for each criminal offense. For each offense, there is a lower and there is a range of penalties, and the law defines the lower and the upper limits of the range, and the criteria that should guide actual determination of sanctions within the range.
Do you have to be within the range? If you're, does the judge have to sentence within the range?
Yes, but then the second step is to see whether there are aggravating or mitigating circumstances, and so he can go up to 3 times the maximum of the range in case of, if there are several aggravating circumstances, he can go up to 3 times the maximum of the range. So prison sentences have a limit which has a general is generally valid. They cannot go beyond 26 years, but that's a very high limit. And in determining the sanction, the court is bound to consider the seriousness of the offense, and as Julian said before, seriousness of the offense depends both on culpability and harm, and the risk that the defendant may commit other crimes. The law indicates a number of criteria that must be considered in making such an assessment. However, the statutory criteria are not very effective in limiting discretion, because on the one hand, there's a very limited supervision by superior courts that often accept reasoning which are rather stereotyped on the application, on the determination of the amount of the sentence. And often the range between minimum and maximum is too wide. For instance, for fraudulent bankruptcy, the range goes from 3 to 10 years imprisonment. And the choice whether to use as a starting point 3 years or 10 years, of course, makes a big difference. And then the judge has a very wide discretion in assessing the existence of aggravating or mitigating circumstances and in balancing the ones against the others. The law indicates which are the aggravating or the mitigating circumstances. We have lists of articles in the penal code which indicate all the different aggravating or mitigating circumstances, but then it's up to the judge to establish if they are present or not, and if the aggravating circumstances are prevail over the mitigating circumstances, you don't consider the mitigating circumstances and you just apply you increase the penalty taking into account only the aggravating circumstances, and so you can really have a big impact on the final sentence. We have alternatives to ordinary trial. Patteggiamento is a kind of sentence bargaining, but so that means that the defense lawyer reaches an agreement on the sentence with the public prosecutor, but then the agreement must be ratified by the court and takes the form of a court decision. It does not imply an admission of guilt nor of facts. So there is no admission of culpability. However, it's applicable only if the sentence which would otherwise be applied does not go beyond 5 years imprisonment, so only if it's lower than 5 years imprisonment. It is considered equivalent to a conviction, and thanks to a patteggiamento, the sentence gets reduced by up to 1/3. Giudizio abbreviato instead is a summary trial. The defendant gives up his right to a public trial, and in exchange, he gets a reduction by 1/3 of the sentence. He gets judged on the evidence collected during the preliminary investigations. We also have a number of alternatives to normal sentencing procedure that concern minor offenses and that can allow the defendant to escape conviction, but I don't have time to go into that. Sanctions for legal entities are pecuniary sanctions, disqualification sanctions, confiscation, publication of the sentence. The most threatening sentences are disqualification sanctions, which can go up to debarment from exercising activity. And so the threat of disqualification sanctions is a very powerful instrument in the hands of the public prosecutor. And to force companies to adopt compliance programs, to compensate damages, to to make available the profit for confiscation, because in this way, by adopting a series of remedial actions, companies may avoid disqualification sanctions. In white-collar crime cases, in Italy, there is a really huge number of criminal offenses that relate to economic activities, but a very small number of white-collar criminals go effectively in prison compared to the rest of them. There's a research made by the University of Lausanne in agreement with the Council of Europe, the Space One report, which gives a rough idea. It's difficult to read, but as you see on the 21st of January 2018, in Italy, 1% of the prison population was represented by white-collar offenders, compared to a European average of about 4-point-something%, and in Germany over 12%. So that's a really big difference. There are several reasons for that. One of the reasons is the statute of limitations, because in about 10% of cases, proceedings are so long in Italy that sentences never become final. And so we have cases of a defendant that was convicted in the first instance, conviction confirmed by the Court of Appeal, and then he went to the Court of Cassation, and the proceedings were time-barred. That happened in the Ethernet case with Mr. Schmidt-Heine, that was convicted to 18 years imprisonment, and the conviction was time-barred when it reached the Court of Cassation.
So defense lawyers can have a major role if they can drag things out until the statute runs?
That's one of the, yes. And in fact, as from 1st of January 2020, in theory, well, if nothing happens before, the statute of limitations will be changed and will stop running after the first instance decision. However, decisions I made a mistake.
Yeah, just leave it.
I don't know how to go back.
Here.
Decisions on corporate cases never get time barred. I don't know how to go back.
That's okay.
Okay, thank you.
That's it.
In corporate liability cases, most case law concerns, in fact, preventive measures. And we have few final judgments because both because, in fact, through the adoption of seizure or the threat of disqualification penalties, companies are pushed to adopting remedial measures that allow them to benefit from a special treatment, and most of them resort to patteggiamento, which reduces sentence and minimize reputational damage. Although I had a case in which a very big, important company was under proceedings for a serious accident at work, and they did not want, in fact, it was very difficult to get out at trial because there were objectively some problems with the procedures of the company, with internal procedures. But they didn't want to consider the possibility of patteggiamento because they said it would amount to admitting implicitly that their compliance program was not adequate. So they decided to fight in trial. And that's it for the moment. So.
All right. Thank you.
Thank you.
Adriana, tell us about Spain.
Thank you. My name is Adriana de Buerba, and I'm with Pérez-Llorca in Spain, in the Madrid office. And I'll try to provide a brief overview of the Spanish sentencing regime. So to begin with, as a general rule, there are no sentencing guidelines in Spain. There is some case law providing general directions about how the court must face the sentencing process, and it includes general principles like proportionality, fairness, reasoning, but also specific rules for a number of offenses, as we'll later see, specifically some of the white-collar crime most typical offenses. So as I'll later develop, the sentencing process in Spain is done in 3 steps. There are legal provisions in the criminal code, establishes a maximum and minimum penalty for each offense. There are procedural guidelines, which in Spain are important because the judge cannot impose a sentence which is more serious than the one requested by the prosecutor. And then there are these sentencing rules I referred to earlier, where applicable. So the court has broad discretion when it comes to sentencing. However, this discretion is always subject to control by the upper court because the court has to reason every time the sentencing process in the judgment in written, so the defendant is able to appeal that sentencing process before the Supreme Court. And this is a constitutional guarantee, and therefore that gave rise to a number of judgments of the Supreme Court conforming this case law I was talking about previously, and describing how the process of sentencing must be approached by the lower judges. Coming to the sentence, it obviously, all the rules regarding sentencing, and that's why probably there are so many differences between one country to the other, depend very much on what are the criminal principles that are beyond the criminal legislation passed in each country, whether the purpose of the sentence is retribution versus rehabilitation in Spain as in Italy. According to the Constitution, the purpose of the sentence is the rehabilitation of the offender. There is also obviously a retribution component as in any other country. And there is also a component of preventing the criminal offense from happening in the future, which can be general, meaning that preventing that citizens would commit offenses, but also a specific prevention system, which means that even though the sentence is determined at the judgment, there are several mechanisms to moderate it during the execution, as the suspension, probation, or substitution, which are very much connected to the risk that the offender might commit another criminal offense in the future. So, having referred very quickly to these general principles, I can go a little bit more in deep in the 3 steps of the sentencing process I was talking about. So as I said, there are legal provisions which establish the rules according to which the judge has to impose a sentence. Of course, there is an extension range associated to each criminal offense. For instance, in fraud is 1 to 6 years of imprisonment. So as you can see, the range is really broad, and therefore there are complementary rules to determine the extension of the sentence in each specific case, depending on the participation of the offender in the sentence, whether he was a principal or an accessory, the completion of the offense, whether it was completely executed or it was attempted, or it was a conspiracy, whether there are aggravating or mitigating circumstances. And I have to say that these circumstances can be generic, like premeditation or confession, meaning that they apply to every criminal offense, or they can be specific for a particular offense. Like, for instance, in case of fraud, it is an aggravating circumstances to perpetrate it through forgery of a signature. And there are other circumstances, like, for instance, the perpetration of multiple offenses or the number of victims, a significant number of victims as a result of the offense. So through these rules, the judge can do this exercise of making these wide range associated to criminal offense more thorough and determine the specific sentence. The prosecutor, there are in Spain prosecutorial guidelines. The purpose is to provide consistency and fairness to the public prosecution action and to provide certainty and predictability to the offenders. They are not binding for the court, but as I said, they are important because the court cannot impose a penalty which is more serious than the one requested by the prosecution. So this is something that should be considered when facing a criminal trial in Spain. And finally, the sentencing rules, which are not guidelines, but are binding to the extent that they come from rulings of the Spanish Supreme Court. So Sandy also asked me to talk about what happens in white-collar crime. Are people sentenced to really long jail time sentence or not? So jail in general used to be rare for white-collar offenders. Typically, they would be sentenced to a penalty of 2 years imprisonment or less in Spain for if you don't have a criminal record, jail sentences of 2 years are suspended, and therefore the offenders did not serve actual jail time. However, in the last few years, that trend seems to be changing, especially in corruption cases. Definitely, we had a number of very serious corruption scandals in the last 10 years in Spain. We recently had a judgment in May 2018 in one of these major scandals, corruption scandals in Spain. It was the Gercke case, and the principal accused was convicted to 51 years of imprisonment, and other offenders were convicted to 33 years of imprisonment. For instance, that was the case for the former treasurer of Partido Popular, one of the two large political parties in Spain, which was in office at the time, by the way. There was no plea in this case, and all the defendants decided to go to trial. The trial lasted 1 year with significant consumption of public money. And there were approximately 40 defendants, and eventually they got convicted, and the conviction was confirmed by the Supreme Court. Surprisingly enough, the sentences have not been that serious as regards financial crime connected to mismanagement of financial institutions. We had several scandals in Spain during the economic recession, and the members of the board of several financial institutions were subject to criminal prosecution for mismanagement or for market manipulation. And most of these cases ended up with a plea. I'll refer to the plea, if I can, a little bit later. And the sentences were always 2 years or less, and therefore suspended. There was a case which went to trial, and the offenders were convicted to 3 years of jail time, effective jail time for market manipulation. But eventually, and in a recent sentence, the Supreme Court changed that and reduced the jail time to 1 year and 6 months, and therefore suspended it. Regarding sentencing legal entities, in theory, same rules apply as for individuals. However, there is a debate about sentencing corporations. They might benefit from these compliance mitigating circumstances and from a specific mitigating circumstances if they pay back the damage caused and compensate the victims. So the debate is whether the individuals might benefit for the mitigating circumstances if it's the company who is paying all the damage that they caused or not. Court seems to think that they cannot. And finally, I can refer very quickly to an example. It is a tax fraud case involving a football player.
That would be a soccer player in the United States.
It is a soccer player. I'm sorry, but we're in English. So
Unfortunately, our Tampa team was here yesterday. They didn't play very well.
So he was a Portuguese, very well-known football player. He was on trial for 4 charges of serious tax fraud, and the prosecutor was requesting a sentence of 3 years jail time for each offense, so that would make 12 years imprisonment. The minimum sentence would have been 6 years of imprisonment, taking into account that the range corresponding to this criminal offense was from 2 to 6 years. But he ended up pleading, and he paid the total amount due plus interest plus a fine amounting to 70% of the evaded taxes, and the prosecution applied a exacerbated mitigating circumstance to reduce the sentence for each charge even below the minimum established by the criminal code, and the final settlement was 2 years of imprisonment suspended. So one wonders whether the prosecutorial guidelines are really meant to provide fairness and a certainty to the defendants, or to actually collect the money and try to push them to enter into a plea.
He's still one of the best players in the world, right?
He's still playing football, thanks heaven, yes.
Let's talk about, just for a few minutes, everybody sort of touched on it, but sort of what would happen in the different countries. So let's just take the VW case as an example and just pretend like that case was in your country. I mean, it is in your country, but you know that it was sort of located in your country. And you know, this is a scheme to create software that avoided the standards that's set by the country for emissions control, and it was created to recognize when the car was being tested, and so when the car was being tested, it was great. There was no bad emissions, but when it was on the road, which is 99 9/10% of the time, it didn't work. So it was violating the standards. But they got certified, and they were able to sell their cars in the United States, and it's billions and billions of dollars worth of cars. In the United States, you already heard that this low-level guy got 7 years. But what would happen if one of these? It really doesn't make that much difference in the guidelines whether you're high level or low level. Our guidelines don't work like that. But let's just say you were being. We know what the prosecution looks like, and it's a wire fraud. We have this wire fraud or mail fraud. It's a fraud count where you use the phones or the wires, because everybody does that now. And under the statute, the statutory maximum is 20 years under the statute, which is pretty much to begin with. And then there's some Clean Air Act counts, and the maximum is only 2 years. And there's a conspiracy count, and the maximum is 5 years. So if you're prosecuted in this and you're convicted, they take the highest count, so the 20-year count, and you go to the guidelines, which now are advisory, but you go to the guidelines and you start at what's called a level 7. And then you add 30 points to that to make it 37, because the fraud in this case, it's all based on the amount of the, quote, fraud is over 550 million. I mean, it's in the billions. So you add 30. So that gets you to 37. And then there's more than 10 victims. You add another 2. That gets you to 39. And it's sophisticated means, because we have all these things that drive up the thing. And that gets you to 41. And there's probably other things, but 41. So what does 41 on our guidelines give you? 41 gives you a maximum of 405 months, or 33 years, and a minimum of 324 months. If you plead guilty under the guidelines as they were, you get 3 points off. So you go from a 41 to a 38. What's a 38 give you? A high of 293 months, 24 years, or a low of 19 months. So, 24 years is a lot less than 33. So you get a break for pleading guilty. And the effect of the guidelines is that a low-level guy ended up with 7 years on a guilty plea. We've already heard from Uli. I think, Uli, what you said is that in Germany, the CEO of Volkswagen would probably not look at more than, 6 years?
Well, I don't know how I will position, but the range for this indictment for serious fraud is up to 10 years. So if he tenders a confession, well, I don't know at which time he would do so, but I don't think for this he would get more than Oliver Schmidt got.
Right.
But to be honest, I can't be that sure, because we have a tendency. What we see, for example, in the Audi case is that the CEO of Audi was detained while he was the current CEO. So German authorities try to demonstrate that they're getting more serious in this case. So maybe we'll see a change. And there's this new indictment against Winterkorn, and also the current CEO of VW and the current chairman of the supervisory board for manipulation of the market, because they didn't give the information on the ongoing procedure in the US to the public as quick as they could have done. That's the accuse. So this might give the option for some more years. So if there's an aggregate sentence, this might be up to 15 years.
And 15 would be the max.
But 15 is the max. If I still can't imagine that he could get 10.
So in England and Wales, with your guidelines.
Yeah, so there's a lot of moving parts here, so it's hard to work out, just going through the guideline as you were speaking. Certainly would be a lesser sentence than he'd receive in the US. And on a quick reading of the guideline, I think it would come in around 3 to 4 years.
3 to 4 compared to essentially life in the United States. How about Spain?
Well, in Spain, the penalty for serious fraud with multiple victims can go as high as 13 years maximum. But then the minimum would be in the range of 2 years. So depending on whether there is a plea and a number of circumstances, that would be the range from 2 to 13 years.
And Italy?
Well, Italy, the penalty for aggravated fraud is not high, because it goes from 1 to 5 years. It can go from 2 to 7 years if it's a fraud to obtain public contributions or so on. But on the other hand, I heard Ulrich was speaking of market manipulation, and there the penalty is much higher, because it goes from 2 to 12 years. So it depends, of course, on the offences which would be applicable in the circumstances. It's difficult to give an answer. It would be in the range of some years of prison. To give you an example of a penalty that was not time-barred and that was really applied, the case of Mr. Tanzi, who was the owner of Parmalat in the Parmalat case. It was a fraudulent bankruptcy. And in that case, he got 10 years imprisonment, and to which you had he had a separate proceedings for market abuse, in which he had 7 years imprisonment, so 17 years altogether. and he spent most of them in jail. Then after a consistent number of years in jail, he managed to get home detention at home. And now I read that he's able to get out 3 hours a day. So he has a permit to go out 3 hours every day, but after many years in prison.
So real quickly, guilty pleas. And we've heard a bit about that. In the United States, I don't know, somewhere Mike Pisano's up there, between 95 and 98% of the cases, I think state and federal, are resolved by guilty pleas. And I mean, that's just the way it is. I mean, the trial, there is a trial, the NACDL, which is the National Association of Criminal Defense Lawyers, did a study last year, and they published it. It's called the trial penalty. And for those of you that are interested, just go online and find it. But, there is a real penalty that is imposed in the United States if you go to trial and lose. And so as a result, and part of it is the guidelines, part of it is, everything else. If you go to trial and lose, you are going to get hammered. There is no, it sounds like, I think we heard from Julian that if you plead guilty, you get, a third off if you do it early. But there is plea bargaining in Britain.
Yeah, it's nothing like the extent that you will find in the US or Canada.
Do you have trials? I mean, we heard from Lisa earlier that that the sentences are low enough to where people go to trial a lot. Is that true?
Well, the resolution rate cases resolved by a plea will be about 95%, so it's no lower than the US. So the trial rate is low.
Still low. In Italy?
In Italy, the rate of pleas, I don't have the exact figure, but I think it's around less than 10%. But then you have other types of alternatives, like the abbreviato summary trial, which is another. So I guess the majority of cases is still ordinary trial.
And in Spain, you do have guilty. You have plea negotiations and guilty pleas.
Not in the American style, and only for criminal offences that are sanctioned with a penalty of 6 years in prison or less, which includes most white-collar crime offences. And I would say 50% of the cases end up with an agreement.
And Uli, you spoke to it. There's no actual plea negotiations that happen in Germany?
No, not that way. We got that deal, but then you go to trial. I've talked about the case of Bernie Eccleston. So the trial was dispensed. You can find a solution like that even before you are indicted. If you have an agreement with the public prosecutor, but well, this is for less severe cases, but there's a wide range of discretion. So you can find solutions. So if it's a more serious case, the public prosecutor will involve the court, telling them, okay, I'm planning to dispense. What do you think about that? And this will be the financial condition. Mostly it's the financial condition. But a guilty plea means you go to court. There's another way of a resolution. It's kind of indictment, but you don't have to go to court. You get it. It's called a penal order. So you get it. It's like an indictment. But if you accept it, it already includes the sentence. So you can see, okay, this is the reproach. This will be the sentence. You accept it. You don't have to go to court. But this is like a judgment finding you guilty. And this is only up to 1 year of imprisonment with a suspension. So you can resolve a huge case like that.
So I think it's pretty obvious that it really makes a difference where you are. I guess we all sort of knew that. We never really focused on, maybe didn't focus on sentencing. In the United States, it's all about sentencing because, we know most of our cases are going to end in plea, and you really try to find a way to negotiate with the prosecutor to find an offense that can, fit within a guideline that you're looking for. Are there any questions? Does anybody have any questions? Yes.
I have a question for Francesca. You spoke about Plenary, and I think no admission of guilt.
Yes, that's
But
right.
it is admitted that it is a judgment.
Yes.
So I see a contradiction between not admitting a guilt and being convicted.
It is a contradiction, you're right, but that's how it works. You don't, I mean, you can pretend you have not admitted guilt and you have chosen patteggiamento for convenience reasons, but then the practical effect is the effect of a conviction. So it goes on your criminal record, it bars you from participating in public tenders, or it has a series of consequences. You don't have, well, a further benefit of patteggiamento in addition to the reduction of the main penalty is that you don't have ancillary penalties except for confiscation, which applies anyway. However, in the case of public tenders, if a conviction, patteggiamento, bars you from taking part in public tenders. So, yes.
Any other questions? Well, thank you so much. I mean, then we have one announcement, but I really appreciate the panel coming from all over, and I think we certainly learned something. Thank you.